This is an advanced event, not a beginner's event. So probably I wouldn't need to say that I'm going to deal with a notion that is the first tramp that appears to the judges that arrive to this area of the EU law, because civil and commercial seems to be something very familiar, something that we know very well from our own systems. And we tend to assimilate our notions and to use it when we have to give meaning to an approach that deals with this notion. But it's not like this. Civil and commercial matters, for the sake of what we are dealing here with, has no relation with our internal notions, has no relation with the nature of the court or tribunal. This means that in some cases even a criminal court can be dealing with a civil and commercial question, and it corresponds to an autonomous notion coming from the EU law exclusively. Why do we need this autonomous notion? Well, in first place, because the objectives are different. The objectives of the EU are different and cannot be confused with the internal goals and concepts. The need for this specific notion also emerges from the existence of two different conceptions of the legal world, the civil law and the common law approaches, that have meanings and notions that are completely different at this level. We must be aware that this concept is not fixed, changing every day. So we need to update it. It's not permanent. It's not identical in all EU regulations even sometimes. It's under construction, and its boundaries are defined according with specific objectives. What specific objectives? Well, the objectives of each specific set of rules that we have to interpret, and the objectives pursued, namely by Article 81 of the Treaty on the Functioning of the European Union. It must be interpreted independently in order to ensure that it is applied uniformly in all member states. It's very important, this goal. Create a uniform vision of what should be inside of the civil and commercial regulations and should be outside of it. It must be coherent with the interpretation of other transversal concepts and rules of the civil EU law. So how can we take a picture to this notion? Essentially through case law, to the European Court of Justice case law. It has been progressively built up through several cases like Eurocontrol, Rufer, Volkersonntag, Preservatrice Foncière, Triard, Apostolidis, Vanenbroek, and we can find new approaches, new pictures of this subject in cases like Leo Kuhn, BNP Paribas, Buak, Agnes Weil, Stephan Real. We are going to talk about some of them. So, reaching this point, it's the time to reveal what is the goal of this intervention. The goal of this intervention, since this is a advanced level training, is to give you a perspective of the new photos that are being taken about this concept. So it's an update, a case law update, the main goal of this intervention. The first case I would like to talk about is the Greek bonds case, the case C-308-17, Leo Kuhn case. The object of this request starts being a request for the interpretation of Article 7.1a of our regulation, the regulation Brussels 1 bis, Brussels recast, or Brussels 1, as you like. It was sought to establish in this case if special jurisdiction should be granted to the courts for the place of performance of an obligation, in this case a very specific obligation, emerging from a contract evoked by the applicant in order to obtain fulfillment of the borrowing terms of bonds. We are talking about bonds in this case, issued by a member state, unfortunately a member state under a crisis, or compensation for the non-fulfillment of those terms in a sovereign debt reduction context. So, a case that emerges from the crisis that you know that has been hitting Europe. In this case, the Greek crisis. The discussion in this case was only justified because all the proceedings appeared in Austria. Because if they had been entered into court in Germany, it would be very different, the solution, because the German Federal Court of Justice, the Bundesgerichtshof, grants immunity, considers that Greece deserves immunity in face of a haircut. So, never raises the question that the Austrian Supreme Court raised, sustaining that the correct decision of this kind of proceedings involves the need of examining the heads of international jurisdiction under the Brussels I regulation. So for the Austrian Supreme Court, this is a question that could or can be inside of regulation Brussels I and be inside of what we generally consider civil and commercial matters. Well, in the pointed case, we find between the major facts that Mr. Kuhn, residing in Vienna, I think we have one representative of Vienna only, isn't it? Only you. You are alone today. Yeah. Mr. Kuhn resided in Vienna and acquired through a custodian bank established in Austria bonds, sovereign bonds, 35,000 euros in sovereign bonds. And they were issued by the Hellenic Republic, by Greece. The bonds were traded at the Athens Stock Exchange. The bonds conferred him entitlement to the repayment of the capital on maturity and the payment of interest. That's what he was expecting. Following the adoption of a 2012 Greek law, unfortunately, the Hellenic Republic converted those bonds, the bonds that Mr. Kuhn had acquired, by new sovereign bonds with a small detail. They had lower value. So suddenly, Mr. Kuhn discovered that he had lost lots of money. And this took him to court. He brought an action before the Landgericht für Zivilrechtssachen, Wien, the regional court, against the Hellenic Republic, naturally. What did he want? He wanted to receive the full money. I want my whole money. I don't want any haircut. This dispute reached the Supreme Court of Austria that tended to consider that there was a secondary contractual claim under Article 7.1a of Regulation Brussels 1a. So there was a contract for the Austrian court. And since the Austrian Supreme Court considered that there was a contract, it decided to stay the proceeding and ask the European Court of Justice where if the place of the performance of the obligation was determined by the borrowing terms or by the place of effective fulfillment of the terms, such as the payment of interest. So the doubt of the Supreme Court was only where is the relevant contractual place. On this field, the court had some relevant previous case like Le Couritou and Vanenbroek. According with the first, certain actions, this notion of civil and commercial matters should be reached by exclusion. This means that should be excluded the application of Regulation Brussels 1 where the public authority should be included, should be included the application of the Regulation Brussels 1 where the public authority was not acting in the exercise of public power. So an exclusion, it was a criteria. In Vanenbroek, the main idea was to appeal to the manifest non-civil and commercial character. So the two clues that the court had to make an approach. And what did the court do to reach his verdict? Well, considered a group of arguments, and the first one was took in consideration the omission of the measure in the initial conditions, taking from this that probably this is not a contractual question because this measure was not in the contract. It appeared lately. By other side, the court considered the universal application of the measure. This is not a question with Mr. Kuhn. It was applied to all the person that acquired the bond, so probably it's not a contractual thing. It's a higher intervention. Also, consider the exceptional context. This happened during a crisis. The crisis gives us the notion that probably this is not a question of negotiation between private interests. And finally, the court had in consideration the exceptional nature of the situation, having in mind that according with Article 12.3 of the treaty establishing the European Stability Mechanism, collective action clauses were to be included as of the 1st January 2013 in all new euro area of government securities with maturity above 1 year. So there was a ruling that took this outside of the contractual questions. The only difficulty, the main difficulty that seeing from the perspective of a judge, that I am, is that the court had a previous notion or a prejudice or a parti pris. It stood on the superiority of interests of Greece, the Eurozone and the EU. So considering that the interests of the citizen were not so relevant or so high as the interests of the Eurozone, the interests of the economy, showing that many times when we talk about rights in this area of civil and commercial, in reality we are talking about instrumental rights to build market. So, what did the court conclude? Well, it reached the conclusion that the mentioned dispute did not fall on civil and commercial matters within the meaning of Article 1, Paragraph 1 of Brussels I regulation. Well, the second case I would like to talk about with you is the case BNP Paribas Fortis that makes the approach of civil and commercial notion coming from the side of the insolvency proceedings. In this case, there was a claim for damages brought by the liquidator in insolvency proceeding, and the proceeds of which, if the claim succeeds, would accrue to the general body of creditors, meaning that he was a representative of all the creditors. I want to collect this amount coming from a claim for damages, and if I'll get it, I will share it between all the creditors. In this case, to reach the conclusion, the court gave us another set of arguments that are relevant to understand the state of the art, let's say, of the building of the notion of civil and commercial. The regulation and the interpretation was still the regulation Brussels 1, 44, 2001, and the court had to compare the scope of this regulation with the regulation on insolvency 1346 2000, and gave us two important elements when comparing to Brussels 1 and any other regulation, in this case the insolvency regulation. We must interpret the two regulations in order to avoid any overlap. Regulations should not superimpose. And we should interpret it in order to do not leave any legal vacuum. Why? Because we have to cover all the civil and commercial matter situations that can appear in Europe, so we cannot reach to conclusions of a sort of a non-liquid. We cannot say what is the solution. So we need to avoid vacuums, said the court. In this comparison also said something very relevant. If we compare Brussels 1 with another regulation, a sectorial regulation, we should have in mind that for Brussels 1 we need a broad interpretation because it covers everything and is residual and subsidiary, and the insolvency regulation should be interpreted through a non-broadly manner, so a specific, focused approach. It also said that only actions that derive directly from insolvency proceedings or are closely connected with them are excluded from the scope of Regulation 44/2001, and evoked cases Gordain and F's text to say this. So, directly derivation from insolvency proceedings, or a very, very, very close connection with them. If not, it's inside of Brussels 1. The decisive criterion to identify the area within which an action falls was, for the court, the legal basis of the action. And the court reminded cases Nickel Goldner's Spedition, Tunkers France and Tunkers Maschinenbau, Mr. Wildspin, Michael Wildspin, that was intended to be here today and that will appear through video conference, intervened directly in these cases. Case Valachan and others. Another element important that the court gave us, it is the closeness of the link between the court action and the insolvency proceeding that is decisive. The ECJ considered, with full reason in my perspective, that the action brought by the liquidator against Fortis was an action for liability for a wrongful act, so it was based on the ordinary rules of civil and commercial law and not based on specific insolvency rules. So this gave us an important clue. And finally, the court considered, well, this claim could have been brought by any creditor alone, by himself. It was not necessarily involved in the insolvency proceeding. In some situations, he would not need the intervention of the liquidator, so it is outside of the insolvency scope. And the ECJ concluded that such an action didn't fall outside of the scope of the Regulation 44/2001. We have a more recent case that uses similar arguments, a case of 18 September 2019, 2 months ago, the case Stephan Real, C4718. The court had to answer to 5 questions, and one of them brought it to repeat some of the arguments of this analyzed case and affirmed with relevance that is decisive to evaluate if the action for a declaration of the existence of claims derives directly from insolvency proceedings, is closely connected with them, or has its origins, this is new, origin in the law on insolvency proceedings. So, derives directly, is closely connected, or has origin in the law on insolvency proceedings. The court made 2 relevant statements that you see on the slide. The first one is that Article 1(2)(b) of Regulation Brussels 1A must be interpreted as meaning that an action for a declaration of the existence of claims for the purposes of their registration in the context of insolvency proceedings is excluded from the scope of that regulation. Why? Registration of insolvency in the context of an insolvency proceeding. Here we are not dealing with strictly civil question that could fall on the regulation Brussels 1A, but we are dealing with a specific case of insolvency. So the court considered that even Article 29(1) on lis pendens should not be applied, even by analogy, to an action which is excluded from the scope of the regulation and falls within the regulation 1346/2000. This brings us to a case that was included in the program, to a group, to a theme that was included in the program, that in reality don't deal with the notion of civil and commercial matters, but with something that has a huge relevance, that is to show how the civil and commercial matters concept is built up from the inside, legal institute by institute, not in the borders, but from inside. And we see several cases, very recent cases, that do this. Helga Lober against Barclays Bank, Phoenix SP, we are going to talk about it, Annika Milivojevic, Reitbauer, Post Nova, Salvoni, DAF Trucks, and ZX. Among these cases, I took 2, Phoenix and Reitbauer, just to talk a little bit about Actio pauliana. That shows us many things, even how sometimes the ECJ forces some conclusions, how sometimes the ECJ reaches conclusions that we don't consider so well balanced, that show that this is a process under construction. So the court is building notions that are under construction. This is not the end of a way. Well, the case Phoenix. What happened in the Phoenix case? A company named Phoenix brought an action against another company named Azteca before the Zesin. I don't know if there is somebody from Poland here to correct. Szczecin. regional court in Poland, seeking a declaration that the contract of sale of immovable property located in that city, in partial fulfillment of prior claims presented by Azteca, was ineffective in relation to it because of the fact that was concluded by his debtor in fraud of the creditor's right. So, to build this action, Phoenix relied on Article 7.1a of Regulation Brussels 1a, but this was not accepted by Azteca, established in Alcora, Spain, that stood for the application of the general rule of Article 4.1. And Azteca also said something very important. This is not matters relating to a contract. Impugnatio pauliana is far beyond contract. It's something different. It has nothing to do. And this is the great problem. And probably we would tend to agree with Azteca and with the general advocate Bobek. But we'll talk a little bit later about this. It was explained to the court that Actio pauliana in the Polish law functioned as an exception to the principle according to which the creditor only has access to the debtor's assets. This happens in the most part of the system. And the Polish code infers from the existence of a close relation between the debtor and the third party a presumption. There is a presumption that the third party knew that the debtor was acting in detriment of the creditor. So the main reason for this action was this presumption of knowledge of the third party about the intention to take some property from the debtor's assets. I'm going to jump the position of the Polish courts, and I would like to, above all, refer what did the European Court of Justice said about what would be the solution and the grounds for the solution. For the court, the application of Article 7.1a presupposes the establishment of a legal obligation freely consented unevoked judgments Engler, OFAB, and Ergo. So here was an obligation freely consented. See how large was the perspective of the court. There is an obligation freely consented behind the impugnatio pauliana, so we must consider that probably we are dealing with contractual matter. By other side, the court said that Actio pauliana is based on the creditor's personal claim against the debtor, seeks to protect whatever security he may have over the debtor's state. Evoked cases Reichert and Kochler. Also consider that impugnatio pauliana preserves the interests of the creditor in the performance of the obligations derived from the contract. So we are still talking about the contract. Reichert and Kochler again. And the court said, if we go deeper, if we go to the cause of the action, what is the cause of the action in impugnatio pauliana? And the court said, the breach of the obligations towards the creditor to which the debtor agreed. This is the problem. Probably the cause of the action was a complex cause that had the contract among it, but several other factors, and the court narrowed the cause of the action here in this argument. And finally, a strong but general argument, the requirements for legal certainty, for foreseeability, that would recommend to have a supplementary ground of jurisdiction that is the contractual jurisdiction, and not only the general domicile rule of Article 4.1. So, what did the court conclude? Concluded that this situation was covered by the rule provided by Article 7.1a, and also said that the place of performance of the obligation was the place where, under the contract, the construction services were provided. Everything started with a construction contract, so the court went to the origins, the first moment of the first contractual moment, to say that that was the place of performance. Obviously, this is not simple. Many of us won't agree. Personally, I have many doubts about this case. I don't agree with it, I must confess. Also, the Advocate General Bobek didn't. And he used an expression that I like very much. He said the impugnatio pauliana has a chameleon-like face. This means that assumes the face of the contract that he is dealing with to protect, but has not the essence of that legal relation. For him, the notion matters relating to a contract was not fulfilled in this case. I would agree strongly. You can find literature, many references to the eventual lack of focus of this decision, even on the net. Unfortunately, I would say, the court recently confirmed this perspective in case Reitbauer. According with this case, Actio pauliana falls under Article 7.1a because it is based on the contractual right. Well, I won't bore you more. Thank you so much for your attention. It was a pleasure to be here.